judicial title. Today, as Richard said, we're going to be talking about charging fees and handling escrow funds for real estate lawyers. The last few ethics programs that I've done with judicial title have been more along the lines of surveys. So I wanted to dig more into the topic and get more into the details. And escrow accounts and fees are really relevant to real estate lawyers in particular, because just about every real estate lawyer makes heavy use or should be making heavy use of their escrow account in real estate transactions. Now, I say we're diving more into a topic. We do only have just under an hour, and an hour isn't enough to talk about even this limited topic, but I'm going to try and hit some key points that I think are important to talk about, whether you know them already and need a refresher or if there's some new information. I hope you'll find something useful in the talk. Okay, as Richard said, I clerked at the disciplinary committee. It's now called the grievance committee while I was in law school, and ever since being admitted, I've been representing lawyers and other licensed professionals in ethics and professional responsibility matters. All right, so we'll go through the agenda briefly. We're going to talk about the escrow account requirements, when you're required to use an escrow account, what types of accounts, and what that looks like in practice. Which account you should use for different types of funds. We're going to talk about client and third-party funds, as well as retainer funds. We're going to talk about when things go wrong in escrow accounts, where there's commingling and misappropriation, and how to prevent that. And we're going to talk about your record-keeping requirements under the rules of professional conduct with respect to escrow and fees. We're going to talk about engagement agreements, what's required, what's not required, and why they're a good idea either way. We're going to talk about also methods of collecting funds and some alternative fee arrangements, because I think that's a bit of a hot topic right now, where people are don't always want to pay by check. Sometimes they want to use Zelle or Venmo or Cash App. So we're going to spend a few minutes on that as well. All right, let's dive in. So what is an escrow account? You probably know this already, but an escrow account could go by several names. It could be called an escrow account, a special account, a trust account. Essentially, it's a bank account where you hold funds that are not yours. They're funds or property that belongs either to a client or to a third party on behalf of a client. And not everyone who acts as an escrow agent has to be an attorney. However, every attorney who handles client funds at some point must have an escrow account. And they must not only have an escrow account, they have to have a certain type of escrow account called an IOLA account. Okay, so why do we need an escrow account in the first place? So the rules of professional conduct and all just about all the rules relating to the escrow accounts are in Rule 1.15 of the New York Rules of Professional Conduct. And I'll mention now that I am talking, this program specifically relates to the New York Rules of Professional Conduct. These are the standards for lawyers in New York. Different states have different requirements. So if you practice in multiple states, make sure you're aware of the different requirements in the different states. So Rule 1.15b1 requires that all client or third-party funds must be maintained in a dedicated escrow account. Essentially what that means is a few things. And we're going to go into this in more detail, but in broad strokes, what it means is you can't mix client or third-party funds with your own property, and you can't mix them with other clients' or third parties' funds unless they're clearly delineated and severable. And the one and whether that there are sort of different requirements for how that can be effectuated if it's in a traditional escrow account or in an IOLA account. Every account that holds client or third-party funds needs to have magic words. And when I say magic words, it's because these words are in the rules of professional conduct. It's an explicit requirement that every escrow account has to be, the name of the account has to have these words, either attorney special account, attorney trust account, or attorney escrow account. It has to have one of those phrases in the name of the bank account, and that name must also appear on all checks and deposit slips associated with that account. So if someone comes to me and says, look, I've got an account, it's called the Tesser firm Iola account. Is that good enough? And although you would think it would be, if you look at the rule, it doesn't have those magic words. So really what it should say is the Tesser firm Iola attorney special account. So if you have multiple escrow accounts, they all have to have one of those phrases in the title. As I mentioned, any attorney who handles client funds must maintain an Iola account. In practice, I think just about every attorney is going to handle client funds on one occasion or another. And so I would say that every attorney should have an Iola account. And when I say an attorney, I mean an attorney or a law firm. Every attorney at a firm doesn't need their own escrow account, doesn't need their own Iola account, as long as the law firm has one. What is an Iola account? Well, let's go to the next slide. An Iola account is a special type of escrow account. You may have heard IOLTA. New York is a bit of an outlier here. We call it an Iola account. Just about every other state calls it an IOLTA account. And the difference between an Iola account and a regular escrow account is that in a regular escrow account, if you're holding funds on behalf of a client, you have an obligation that those funds should be interest-bearing, and you need to be able to identify the particular interest that accrues on an individual party's funds so that you can allocate that interest to the party that you're holding funds for. Let's say you have an escrow account and you want to hold 3 different clients' funds in that escrow account. Well, if it's an interest-bearing account and there's no sub-accounts, it's just one big escrow account and it's not an Iola, then you can't put those 3 clients' funds together, or you're not supposed to put those 3 clients' funds together, because there's no way, even if you're doing all the record keeping, there's no way to track what interest belongs to which client, because the funds are all mixed up. So if you are, if you are holding a large amount of money that's intended, that you're expecting will accrue a relevant amount of interest that, the client would notice, would want to receive the interest, or the third party would want to receive the interest, then you've got a few options. You could open a separate account just for those funds. You could put those funds into an escrow account that has sub-accounts so that that can track the interest that accrues for each party's funds. But like I said, you can't just put it into an escrow account together with other funds with no sub-account where you can't track the interest. And here's where the Iola account comes in. You'd say, well, what if it's a small amount of funds, or it's only going to be in there for a small amount of time? The interest really isn't a relevant factor for that. Do I have to open a sub-account or a whole new account to put those funds in? No, that's what you can use your Iola account for. The Iola account is a place where you can put different third parties and clients' funds together, subject to your record-keeping requirements, but you don't have to identify the interest that accrues, because the interest goes to the Iola fund, and that is an appropriate. That's appropriate if it's. But you have to use your judgment about whether the amount of escrow, the amount of interest, pardon, that is expecting to accrue on funds, whether that's something that should appropriately be reserved for the client and go into a segregated account, or if it's something that you think is going to be de minimis and you're better off giving the minimal interest to the IOLA fund. A question I often get asked about is retainer funds. Where do you put retainer funds? Should those go in an escrow account in the IOLA, or should retainer funds go into your operating account? Well, this is one of those questions where it's very important to know what your state does, because different states do very different things. New York actually is a little bit of an outlier. In New York, you are not required to hold retainer funds in an escrow account. It is perfectly fine for you to put retainer funds directly into your operating account. Subject to of course, though, if you end up having to return funds because you don't complete a representation or if you don't use the full retainer, you're still responsible for returning those funds. But it's not an escrow violation. It's just one of your obligations. And I encourage you to read New York State Bar Formal Opinion 570. It was published in 1985, which discusses what you're supposed to do with retainer funds. Part of the rationale, I believe, is that what the rule was earlier in New York and what it is in many states is that you have to, when you put your retainer funds in an escrow account, and as you earn the funds, you can withdraw them and put them into your operating account. The trouble there is if you, take a little bit of time in withdrawing the funds, then all of a sudden you're commingling, which is also against the rules. So I think for the sake of simplicity and avoiding accidental commingling, New York's come down on the side that you're allowed to put retainer funds in the operating account. But beware, I think we were going to talk about this more a little later, but I just want to note now that just because you're getting funds at the start of a representation doesn't necessarily mean that it's retainer funds and that it can go in your operating account. So if you have an engagement agreement where you say, we're going to take, let's say my hourly rate is X, and let's say the hourly rate is $300. And I'm taking a retainer of $3,000 and $1,000 for prepayment of filing fees and other expenses. So you get a check for $4,000. You say, great, this goes to my operating account. It's all a retainer. Well, actually, the $3,000 is the retainer and can go into the operating account. And the $1,000, that's not your money. That's not a retainer. That's prepayment for fees, payment of expenses. Those are client funds that you're holding on their behalf. So that has to go into an escrow account. It would be easier if the client gave you two separate checks, one for $3,000, one for $1,000, and that's, if you're getting upfront fees, that's what I would recommend. But say the client gives you a check for $4,000 and they're not going to return it, you should not deposit that into your operating account and then send the $1,000 to the escrow account. That $1,000 is never allowed to touch your operating account. It always has to go straight from the client to the escrow account to where the client is directing you to pay it. So if you get that $4,000 check, including both retainer and expense funds, it should go into the escrow account first, and then you can pay out the retainer into the operating account. It shouldn't be the other way around. I see there are some questions coming in. I'm going to do my best to take a look at them and answer as we go if they're on topic for what we're talking about. And if it's a little outside the topic of what we're talking about, I'll try and get to it when we get to the end of the program. Okay, we're going to talk about preserving the identity of funds and commingling. there's a big rule. You can never mix personal funds with client or third-party funds. In addition to personal funds, if you're acting as a fiduciary, as a trustee, an executor, or other type of fiduciary, you can't just use your escrow account as a trust account, as an estate account, and commingle it with other client or third-party funds. Those funds have to be retained separately. So, and that is one of the reasons why, even though you're allowed to use an escrow account or an operating account for retainer funds, I prefer to use the operating account. Like I said, if you earn funds, then technically those are yours. And now you're mixing funds with a client or third party. There are some exceptions to this. You are allowed to maintain funds within an escrow account containing client or third-party funds, which are funds that are reasonably sufficient to maintain the account to pay account charges. First of all, when you're opening an escrow account, you should always make sure that there aren't monthly fees and that you're not going to be charged, fees, unexpected fees from the bank. But nevertheless, the rules of professional conduct do give some allowances just to make sure that, in the event of a bank fee, that no client's funds are invaded. They don't tell you a particular amount that you can put in. Some say $20, some say $50, some say $200. My advice is to deposit $100 in any of your escrow accounts of your own money. No more than that is really necessary. But that's an amount that no grievance committee is going to take issue with, and it's going to protect you and your clients and anyone else you're holding funds from unintentional invasion of funds by the bank. You have to preserve the identity of funds. We talked earlier about having to be able to track the funds for the purpose of assigning interest. But even if you don't have to worry about interest, if this is in an IOLA account, you still have to know at any given time how much of the money in the account belongs to or is related to which client or to which party. And at any given time, you have to know how much money you're holding on behalf of a particular person, where it came from, and what it's supposed to be used for. And we're going to talk more about this later when we go over record keeping. Here's a big rule about preserving the identity of funds. You can make no debit transactions with the debit card, no cash withdrawals, and no checks to cash from an escrow account. I put this in all caps because there are no exceptions. No ATM withdrawals, no debit cards, you should never accept a debit card. If someone gives you a debit card for an escrow account, you should cut it up. And don't write any checks to cash. The reason is because we can't track these funds. Say a client says, I need cash, don't write me a check. I need cash, go take out some funds and give it to me in cash. We're not going to be able to prove after the fact that that's where those funds went. There's a big requirement of escrow accounts is that, you should be able to look at your statement, look at your ledger, and know where all the funds went and where they came from. Another thing that's sort of a developing area, and this is something that we talk about a lot on some of the bar committees that I'm on, is, are you allowed to do wire transfers from an escrow account? Some of you might be going, what? Of course you can. Everyone does that. And to some extent, I can't disagree with that. It is the common practice, and I think most people are doing it. There are some who still oppose it. For example, the third department grievance committee is very opposed to wire transfers from escrow accounts because they don't necessarily identify the recipient or a description of the funds, whereas a check, you can always show the recipient and put in a description. Even the third department is coming around on it and are sort of realizing that wire transactions are here to stay. But with that in mind, they have legitimate concerns that they're, if you're making transactions that don't have identifying information, it's a risk. So if you do have an opportunity, if you are making wire transactions, I would say make sure to put the recipient and a description in the description of the transfer if you're able to do so. Okay, I see a question from the chat. What if the bank returns non-sourced funds to the account years later, never tied to client bank internal adjustments? When you say non-sourced funds, I'm going to answer it two ways because I'm not sure what the question is. If the question is relating to that $100 that you put into your account, and then those are your funds. And if the bank returns non-sourced funds to the account years later that was never deposited by your office, never tied to the client, it's going to depend on the facts of the situation. There is a procedure where if there are funds in your account that you're not able to identify, or if there are funds that you're able to identify but you can't reach the person who owns the funds, there is a procedure to submit a petition to the Supreme Court for an order directing payment of those funds to the Lawyers Fund for Client Protection. That's usually a safe way to go, but it's really going to depend on the facts of the situation. Okay, misappropriation is the next thing we're going to talk about. What is the difference? And I'm realizing I'm talking a little fast. I'm going to try and slow down. Oh, we've got another question. Let's take a look, and maybe we'll go to that before we move on. All right, what if the check from the client intended for escrow passes through another account out of convenience? In other words, if there's a deposit error or a banking problem. Okay, that's a good question. And we're going to touch on something related to this a little later, where people want to do things out of convenience, such as through like a Venmo or a Zelle account that is tied to an account other than an escrow account. But this question's a little different. This question is, what if because there's a bank error or if you make a mistake? If it's a bank, I guess the answer is the same in either case. The answer is to just correct the mistake as soon as possible, as soon as you realize it. So if you accidentally deposit, whether you accidentally sign a check, endorse it to your operating rather than your escrow, or if you intend to deposit to your escrow but the bank makes a mistake, you should transfer the funds over to your escrow account as soon as you discover it. I would do it by check, so that, like I said, you can have so that you can have it, show the description, show where the funds are going, always keep a paper trail. It's also a good idea to write a memo to file, so that you can contemporaneously make a note of what happens if you ever have to recreate it. There was another question, and I see that there are questions in the chat and questions in the Q&A. I've been going through the chat. Moving forward, let's put questions into the Q&A so I can keep them in one place. I didn't even realize they were in two places until now. Thank you for letting me know. There's another question. Can I pay my client's expense, like a real estate tax, by making a direct withdrawal from the IOLA account? No, you should not be doing any direct withdrawals. Well, I guess it depends what you mean by a direct withdrawal from the IOLA account. if you can write a check directly from the IOLA account. As we were discussing, you can do a wire transfer from the IOLA account. Maybe if you're discussing an ACH withdrawal, I think that would be okay if you can identify it, if you can put those identifying information to track the funds. But if you're talking about doing a cash withdrawal, you can never do that. So, what I would say is, if you can properly identify the transaction, and show on the bank statement, what the transaction is. Off the top of my head, I think an ACH is probably comparable to a wire transaction and would likely be judged on similar standards, which, my instinct is probably okay, but make sure that you can track it. That's my instinct, and I don't know if there's an ethics opinion about that. And if you want to send me an email after the program, I'd be happy to look into it and continue the conversation. Okay, I want to move on with the program. I see that there are a number of questions in the Q&A, and we will get to them. But I want to move on with the program a little bit more first. Okay, let's talk about misappropriation. If commingling is mixing funds, your own personal funds with client funds, misappropriation is I shouldn't say slightly, it's the more serious of the escrow violations, where you're not only mixing, but you're actually using client or third-party funds for purposes other than what they were intended for or directed by the client. You might have heard a term conversion. What does conversion mean? Well, technically, the word conversion isn't in the rules of professional conduct. All misappropriation is just a misappropriation. But colloquially, we use the term conversion when there's a misappropriation made for the attorney's benefit. It's misappropriation plus theft, basically, is conversion. How and when does this occur? Is it intentional? Sometimes. Do lawyers steal from their clients? Do they use escrow funds of one client for someone else's benefit? It happens intentionally, but most of the time it's unintentional. Most of the time when there's a misappropriation, it occurs because an attorney is not maintaining the records that they're supposed to be maintaining, if they have an issue with organization, if there's a clerical error. Most of my clients who have misappropriated client funds have not done it intentionally. I'll give you an example. Let's say you get a check and you think you deposited the check, but you didn't actually deposit the check, and then you pay out funds that were supposed to be provided by the check. And then all of a sudden, you're using funds that belonged to another client because that check wasn't deposited and you didn't have the funds to cover the shortfall. Now, why did this occur? Well, two reasons. There were two instances of carelessness. One was not depositing the check in the first place, or ensuring that the check cleared even if it was deposited. And the second instance of carelessness is when they paid out the funds when they paid out the funds, the attorney did not check to ensure that the funds were there in the account, or if they did check, their records weren't robust enough to show that the funds weren't available. And so the takeaway is that anytime you're dealing with an escrow transaction, you have to be incredibly careful and check and double check and make sure that anytime you're paying out funds from an escrow account, that you have the funds in the account to clear. And anytime that you're provided with funds that should go into an escrow account, you need to make sure that it goes into the escrow account expediently. Okay, some people ask, okay, well, what if I, accidentally or intentionally paid out funds from an escrow account that there weren't corresponding funds, but I put them back in the next day. So there's nothing wrong, right? Well, restitution is always helpful. If you made a mistake, you should correct it, but that doesn't mean there wasn't a violation of the rules, and that doesn't mean that it's not going to be taken seriously. It will be. Anytime there's an instance of a client or third party's funds being invaded, the grievance committee is going to take that seriously. And that doesn't necessarily mean you're going to get suspended. But it's something that should always be taken seriously. If there's any, if it ever happens intentionally or unintentionally, it's a good idea for you to speak with an ethics lawyer and make sure that it's corrected and that any inquiries by the grievance committee are handled appropriately, because they do take it very seriously. One thing to be aware of that many of you probably know is if a check is dishonored from an escrow account, then the bank is required to make a report to the lawyer's fund for client protection, and the lawyer's funds will then thereafter make a report to the grievance committee, who will open an investigation. And so how do you avoid an accidental misappropriation? Well, record keeping is very important, and we're going to talk about that in just a second. Another thing to be aware of is be very careful if you feel like a client is asking you to do them a favor, or if you're breaking procedure, or really you should stick with your procedure. I've represented a number of attorneys who were just trying to help a client out. Let's say a client gives a check and says, here, I'm giving you a check, but I don't have funds, don't cash it yet, cash it on such and such a date. So you're waiting for the funds to clear. You go to a closing and you write out checks from your escrow account and say, here's a check, don't cash it yet until I tell you to. And then lo and behold, the title closer or the other party's attorney goes ahead and cashes the check. It doesn't matter if you told them not to cash it yet, you still gave them the check, and that's going to be a problem. So keep good record keeping, and beware when people are asking you to do them favors and to go out on a limb, because I do see people get in trouble that way. Okay, we're going to close up this section of the program by talking about record keeping. There are a number of requirements for record keeping that are in Rule 1.15 D2. And they talk about what records you're required to keep with respect to client or third-party funds that you're holding, essentially escrow account records. And we've sort of been talking about this the whole time because it's so important. But you have to make sure that your records clearly identify the ownership of any funds that cross through one of your escrow accounts, even if it's just temporary, even if it's just for a day. You need to be able to go back in time and show that at any point how much money you're holding on behalf of each each client, each party, and what those funds were for. And when funds go in or when they're distributed, you need to be able to clearly identify the parties to and from whom those funds are received and distributed. Okay, so what records are you, so how do you keep track of this? So you have to keep track of a ledger, and the ledger, like I said, has to show each transaction. And for each transaction, the ledger should show, you should have the date of the transaction. It should have the amount of the transaction. It should have if funds are coming in, where it's coming from, or who it's being paid to. It should have the client with whom the funds are associated, the client matter, and it should have, for each transaction, there should be a running balance of how much money you're holding on behalf of that party or in connection with that matter, so that at any given time after each transaction, you can see how much funds are remaining, and whether you can, when you're paying out future expenditures, you can refer to that. Another thing that you want to keep note of is if you've issued a check, whether it's been cleared, if you've deposited a check, whether it's cleared. I think it's a good idea to make a note on your ledger whether transactions are pending or finalized, because those are things that can trip you up. You're required to retain records for 7 years. A lot of people think the 7-year retention refers to client files. Actually, it doesn't. It really it actually only refers to escrow funds and financial transactions with the client, your legal fee and escrow funds. So that doesn't mean that you can throw away clients' files immediately. There are other rules that guide how you should dispose of and maintain client files, but that's for another talk. So what are you required to retain for 7 years? So you need to keep your contemporaneous ledger dating back at least that far. You need bank statements for all escrow accounts. You need canceled checks. You need deposit slips. You need any bills rendered to the client, and retainer agreements over that 7-year period. Okay, what do you do if you have funds that are in dispute? In other words, you have funds in your escrow account that are, that multiple parties say that they're entitled to. So what you should do is you should pay out any portion that's not in dispute, and any portion that is in dispute you should hold pending the outcome of the dispute. And that's covered by Rule 1.15b4. One thing that's more a guidance in the State Bar comments to the rules, which are not binding but instructive, they say don't act as an arbitrator. It's really not your role to decide if funds are in dispute, who they belong to. When you're an escrow agent, you're acting as a fiduciary, and you're not acting as an arbitrator. You can get into trouble if you're really making decisions that ought to be made by a court or another decision maker as to who's entitled to funds. Now, listen, that doesn't necessarily mean that if someone makes a totally frivolous claim that you have to honor that. But it's a dangerous situation still, and most of the time, if there's any type of dispute, it's safer to hold the funds pending the resolution of the dispute. Okay. What are some other escrow issues? We talked about this. I mentioned it in response to one of the questions. What happens if there are missing clients or funds that you can't identify? As I mentioned, you may have to bring an action to the court. There is a procedure to petition the court for payment of funds. Often you'll be petitioning the court for payment of the funds to the lawyer's fund for client protection. And then anyone who's entitled to the funds can go to the lawyer's fund to retrieve those funds. And if you're running into other issues, other questions with regard to an escrow account, the best advice I can give you is talk to an ethics attorney. Call me, call another attorney who practices in this field. Most of us are pretty friendly, and we'd be happy to chat. Let's go to a few questions before we move on. Okay, here's a good question. I I see a question about, I'm not going to, it's a good question, but I'm not going to address the question about the IOLA funds being diverted. It's a political question. It's not a legal ethics question. It's outside the topic of, of the presentation. We don't have enough time to go into that. Even though, I think it's worthy of discussion. One of the someone asked is, it's not really a question, but I think it is important. They say that you have to be careful with your bank. They recently got a call from a bank telling them they were going to close an IOLA account because it wasn't under their taxpayer identification number. And the participant said that he quietly explained the facts of life to them. So yeah, that is one thing to be aware of, that banks, you would expect to be really familiar with the rules regarding escrow and IOLA accounts, but sometimes they unfortunately are not. And not every single person at the bank is going to know what all the rules are. And, frankly, as much as we'd like to be able to rely on them, it's not their responsibility. It's our responsibility as lawyers to know what the rules are. So, bank error can be a defense if the bank makes an error. It's our obligation as lawyers to make sure that escrow funds and accounts are handled properly. Let's take a quick break to do the course code. The course code for credit is the number is 115. It's 115, as in Rule 1.15. Okay, another question. What happens to an IOLA account if the sole proprietor dies with funds in their IOLA account? That's a great question. And it's one that both ethics lawyers and estate lawyers have to deal with. Well, there's two situations. What I would recommend is that, what we often recommend is that you make if you're a sole practitioner with an escrow account, that you make an agreement with another law firm, that you can name another lawyer as a successor fiduciary of the escrow account. So that way, once, if something happens, if God forbid you pass or are incapacitated, then there can be uninterrupted service, and it'll prevent it'll prevent disruption to the clients. If there is no successor, then someone who has an interest would have to make a petition to the Supreme Court for transfer of those funds. In New York Supreme Court, a successor lawyer, an executor, someone who's entitled to the funds, or someone who's for whom the funds were being held, all have standing to make that petition. I recommend that it be a successor or an executor, because they can, handle all of the funds rather than just the funds that relate to them. Okay, this question about if you have a small amount in your IOLA account that you're unable to return to the depositor because they can't be located, I think I answered that. You make a petition to the Supreme Court. There's a particular form, and the forms for these petitions are available actually on the website for the Lawyers Fund for Client Protection. They're not entirely up to date. I've used one of the forms and then the court told me they wanted it another way, but it's a good start. Is an IOLA account optional or mandatory for escrowed funds? If you have escrowed funds, it is mandatory to have an escrow account, an IOLA account. It's not necessary. There are funds that you're supposed to use the IOLA account for if they're called covered funds in the IOLA law. If it's a small amount of funds or holding it for a short amount of time, you are supposed to use the IOLA account, but that's getting a little into the weeds, and it's more of an I'd encourage you to read the rules of the IOLA law if you want to get a better understanding of it. This is a short program. Um, as a representative of a seller of real estate, is it acceptable to take a payment pursuant to a letter of engagement for fees out of a down payment once a real estate closing takes place? I mean, if I guess the question is if it I think I'm going to dodge the question a little bit because I think that if the engagement agreement provides, oh, you're the seller, so you're getting the funds from the down payment. Yeah, sure. If the engagement agreement says that you can take your fee out of the down payment, I don't see any problem with that. As long as it's, if that's in the engagement agreement, then, that's the instruction of the client. I'm okay with that. Regarding closed IOLA accounts, my understanding is that record retention rules regarding monthly bank statements, check registers, and the like has been that the originals must be maintained for a number of years, whereas it would be far more convenient to create related electronic documents and discard the originals. Is there any available insight on whether this is permitted? I don't know that I'll give you an answer you can rely on, but generally speaking, I'm not aware of anything in the rules that you would be required to maintain an original. They say you have to keep copies of canceled checks and copies of deposit slips. My instinct and my experience with this is that a digital copy, as long as it's secure, is sufficient to comply with the record keeping requirement. I'm going to do one or more questions, then we need to move on with the program. What if someone never cashes an escrow account for a transaction and you have a small amount, say 250 to 1,000 sitting in your trust account? What is your duty as to those funds? Can you leave them there? Yeah, sure, you can leave them there as long as they're safe, as long as they're protected and maintained and identified and segregated. That's perfectly fine. Although, just for record keeping, for your own benefit and ease, I like to get funds where they're going as quickly as possible. So I would probably be on top of the person to cash the funds, or if they're not communicating, if you can't reach them, then you can bring that petition to the Supreme Court to deposit the funds with the lawyer's fund. But no, it's fine to keep them in your account as well, as long as you keep good records. I'm going to do one more question, and then I'm going to keep going with the program. We can go back to questions at the end if we have time. Isn't it better to pay an expense out of your funds and then get reimbursed from the client's funds to avoid misappropriation? That's a great question. And usually that is what I do. So, I said if you're taking, a retainer fund as well as funds for payment of expenses, the retainer can go in operating. The expense fund has to go into the escrow. That's one way to do it. Another way you could do it is in the engagement agreement. You can say, I'm taking, retainer of $4,000, and any out-of-pocket expenses will be reimbursed by the client and can be taken out of the retainer. That's another way to do it, where you wouldn't have to put any money into escrow. Because you're not holding those funds specifically for payment of expenses. They're just being used for reimbursement of out-of-pocket expenses. So that's fine. Not everyone can do that. Sometimes if you're doing a flat fee matter, or if you're doing, if you don't have the funds to front, you need the funds from the client. Those are limiting factors, but that is a good way to do it if you can. Okay, we're gonna rush through the rest of the program. We've only got about 5 minutes left. I know there are a lot of other questions. I'd love to get to all of them, but I don't think we're gonna have time. If I don't get to your question, then please, my contact information is at the end of the program. Feel free to shoot me an email, give me a call. I'm happy to chat. Engagement agreements. They're not always required, but they're always a best practice. I always encourage you to use an engagement agreement for every single matter, even if it's not required. It limits the scope of representation. It avoids the situation where, say, you take a flat fee for a project and your client says, and I thought for doing A and B, and the client says, I paid you a fee for A, B, and C. The engagement agreement limits that scope. It sets expectations about fees, communication, responsibilities, etc. If you are required to have an engagement agreement, it must explain the scope of services. It has to explain fees, expenses, billing practice, and the right to arbitration under Part 137. Like I was saying, it's not required if the the representation is expected to cost under $3,000. If it's a repeat representation of the same client, of the same general kinds of representation, if it's a domestic relations matter subject to Part 1400, or if it's not a New York representation where it still may be subject to engagement agreement requirements in other jurisdictions. But like I said, I always 100% of the time encourage you to have an engagement agreement, even if it's not required. Let's talk about methods of collecting funds. I'm sorry we don't have more time to talk about this. We're going to have to breeze through it a little bit. I have a lot of people asking me if they can use Venmo, PayPal, Zelle, other payment processing services for collecting fees, collecting escrow funds. And some people ask for forgiveness rather than permission. Well, let's just go back. We have to go back to the rules. There aren't special rules for this, but they have to follow the rules that we've prescribed. So if it's escrow funds, it has to follow Rule 1.15. If the transaction results in commingling or unidentified funds, it's not permitted. So, one of the problems with this is, a Venmo, a PayPal, these have to be linked to a bank account. And a lot of, so if you have a Venmo account or a PayPal account that's linked to your operating account or a personal account, and a client wants to pay you by Venmo, if it's a retainer fund, then I don't see anything wrong with that. But if it's escrow funds, then by using that service, it's passing through a non-escrow account, and that's never permitted. Can you link a Venmo or a PayPal to an escrow account? Maybe. It's very risky. There are a few things that I'd say you have to be aware of. One, watch out for fees. You should not be using a service that's going to be taking fees out of funds that are third-party or client funds, or out of the account generally. And you should not be using a service where you're unable to identify the funds or the recipient. If the bank statement just shows transfer from Venmo and it doesn't show whose funds those are, you could maybe make an argument that the Venmo records would show where the funds came from, but it's really dangerous, and is just asking for trouble, asking for things to get mixed up. I would caution against it at this time. As these services become more commonplace and mainstream and expected, there may be further guidance on what's appropriate. But for now, I would say you probably don't want to be the test case that an ethics article gets written about. So, for now, I think, checks and wires are a best practice. If there is a service that for sure can identify, that doesn't take fees, that you can identify from your bank statements where the funds came from, where the funds are going, then it's probably all right, but you have to be very careful. We talked about this already, dealing with expenses, whether you should take funds. We talked about this, whether take expenses up front or reimburse them from the retainer after the fact. We don't really have time to talk about these, but I just want to bring it to your attention that sometimes I get asked about alternative fee agreements, accepting interest in a property or accepting cryptocurrency for a representation. And to make a long story short, it's risk. It's not, categorically prohibited, but it does often qualify as a business transaction because between the lawyer and the client. Because when the lawyer obtains an interest in a property or in cryptocurrency, they may have different interests than the client in what to do with that property, and that might be related to the subject of the representation. If you can exercise reasonable judgment, if the transaction is fair and reasonable, you get informed consent from the client. The client has the opportunity and is advised to seek independent counsel. It might be okay. You still have to comply with Rule 1.7a. You can't represent a client if there's a significant risk that your professional judgment will be adversely affected. Just one quick note about crypto. You may be wondering, well, why can't I take crypto as a retainer fund? Well, maybe you can, but it is something that is risky and has been the subject of discussion both by the ABA and the City Bar. Really, the concern here is what do you do with it? A lot of the time where people have come down is if you take crypto, it's safest if you liquidate it immediately and put in your retainer agreement that that's what you're going to do. Because if you hold on to it and the value changes, and then your services are terminated and you have to return the funds to the client, then there's a question of, do you have to return the value at the time that it was paid or the present value? It's very messy. So I would really hazard you, but this is another developing area. I would love to keep going. There's so much more to talk about, but we're all out of time. My contact is on the screen. Please feel free to reach out. Thank you again, Diana and Richard and Judicial Title for having me.
Thank you so much, Randy, for a great presentation. Just a reminder, everyone should have their certificates by next week, and I'll send all the materials shortly. I think you broke the record on questions in a single presentation today. So it looks like everyone really enjoyed it. So thank you again for your time. We really appreciate it.